Hi folks, this is Jeff from Distress Loan Advisors and welcome to part 2 of our common questions about SBA loan default. If you haven't already, be sure to check out part 1 of this series. And again, visit us on the web anytime to find much more about the SBA loan settlement process. Our first question for this video is, I paid too much for my business. Will my lender or the SBA reduce the principal amount I owe so that I can afford the payments? Sadly, the answer to this is no. The only way that the SBA will consider a settlement is after the business ceases operations and all business assets have been liquidated. I should note, however, that some exceptions to this do apply. Some people will seek to sell their assets to a related party, such as a friend, relative, or business partner, then buy them back later. Unless this is explicitly disclosed and approved by the SBA and the lender, this could, however, be construed as fraudulent. Our next question is, how much will the SBA be willing to settle for? There's no set formula for that. Different banks have different policies regarding how much they're willing to settle for. Some don't have set rules, while others take a hard stance and pick a number, stick to it regardless of your personal situation. Very often, how much the SBA is willing to approve will depend on the personal financial situation of the guarantor. The third question for this video is, do I need a lawyer to settle my SBA debt? The answer is no. Settling SBA debt is largely a financial matter. While we'd recommend having an attorney review legal documents, the fact is that SBA settlements often involve no signing of any agreements at all. When engaging someone to represent you, you need someone with a thorough knowledge of the SBA process. Many lawyers don't have that, and an understanding of the philosophy behind SBA settlement policies. Let's consider foreclosure next. Will the SBA foreclose on your home? If there's equity in that home and you're unable to reach a settlement, foreclosure is a possibility. The best way to avoid such a situation is to get the debt settled prior to the SBA or your lender ever starting the foreclosure process. Most lenders prefer not to foreclose and are willing to work out payment arrangements to keep you in your house. Next, let's consider a process question. If I want to settle my debt, I sell my business assets and turn over the cash to my lender, right? Sorry, but no, that's not the case. Selling the business assets is just the liquidation phase. After the cash from the sale of the assets is applied to the principal balance, only then do settlement negotiations begin. Settlement discussions can only be had once the business ceases operations and all business assets have been liquidated. And our final question for this video is, why are your fees at Distress Loan Advisors lower than those at other workout firms? We believe our fees are appropriate for the services we provide. While we're in business for profit, we also feel responsible for the well-being of our clients, which means doing the right thing and charging reasonable fees for our services. Rather than charge no fee upfront and a whopping percentage on the back end, we charge a reasonable upfront fee for time spent and take a reasonable percentage upon a successful settlement. For much more information on the SBA loan settlement process, visit us online at www.jasontees.com. And if you'd like information about your personal loan situation, give us a call at 631-428-1978 or drop us an email at jason@jasontees.com.